Hello, everyone. Thank you very much for joining us today. I'm Kaylee Swift. I'm one of the directors here at NB Property Law, and we've also got Sebastian and Tony DeCourt from Faces in Brisbane. So appreciate them both coming along as our guests today. So as you know, topic for today is family, home and wealth dilemma. So we're be talking about asset protection and aged care planning in Australia. So a little bit about myself and NB Property Law. So as I mentioned, I'm the director here. Basically, I like to showcase that, I've got expertise across commercial property and estate planning law. I work closely with individuals, families and business owners to help them navigate their complex property transactions, commercial contracts, and also long-term asset protection strategies with confidence. So I've got extensive experience in estate planning and commercial law matters, and I advise clients on their wills, testamentary trusts, asset structuring and succession planning, ensuring that their wealth and business assets are protected both now and into the future. So I combined my commercial and property law experience to enable me to be able to deliver integrated strategic advice that supports the business growth of our clients, their risk management, but also their long-term wealth preservation. So I'm passionate about commercial estate planning and property law, and I'm always striving to provide that holistic, practical legal advice to align with what my clients' broader financial and business objectives actually are. Above all, though, I prioritise delivering advice in clear commercial terms to ensure smooth transactions and the outcomes that actually genuinely support what my clients want to succeed. So I'll hand over to Tony and Seb to introduce yourselves, please.
Oh, thank you. Faces is a family-run business. We dedicated to helping Australians navigate the financial complexity of aged care with confidence, clarity and control. I was the founder and I've been around the financial services field for over 45 years in financial planning, property and estate planning. And Faces, which stands for Financial Aged Care Entry Solutions, was built on a simple philosophy to give people the facts, show them their options and empower them to make informed decisions when it comes to aged care. In the last 18 months, I've been joined by Sebastian, my son, who brings passion and a fresh, innovative approach to make aged care and pension guidance more accessible through technology and automation. And together, our mission is to provide everyday Australians with facts and options so they can navigate the financial aged care space with confidence and empower them.
Wonderful. Thank you very much for that. So our agenda that we're going to run through today, so we're going to talk about the risks when aged care actually looms. So what's at stake financially and legally when aged care becomes a reality for your family. We'll go through what the gifting rules and implications are. So how Centrelink's deprivation rules actually affect pensions and aged care fees and what gifting actually really costs. I'll be speaking about the granny flat agreement. So what is a granny flat agreement from Centrelink's point of view and the legal structures involved in that. Tony and Seb will talk about the true financial costs of aged care. So year one costs, the fee types, the means testing, the real numbers that families face without actually having a plan in place. They'll go through the common mistakes that are overlooked and the traps. So talking about the decisions that significantly impact family wealth and how to avoid them. And lastly, they'll be speaking about the practical planning insights. So what families can do today to plan ahead with greater confidence and preserve their legacy. So to start off with, I'm going to talk about transferring property, so to children or related parties to assist in reducing your assets that you've got. So obviously anyone can give property to another party. You can sell that property as well. It could be for less than market value if you're looking to do that as a gift or partial gift. And you can sell part interest in the property while maintaining a legal interest still in that property. So essentially, if you have a mortgage, though, over a property, obviously that does need to be released if transferring the property to someone else, whether by refinancing it or transferring part of that property. So, if there is a mortgage, it needs to be paid out essentially before the property can just be transferred and released to someone else. The financial considerations, though, to consider when transferring a property is for the recipient transfer duty. So they've got to pay transfer duty based on the property's market value, not the price paid. So if we are gifting property to a family member, it doesn't matter that they're potentially paying nothing for that property. They still have the burden of paying for transfer duty at what would be the property market rate. So, that really depends on what the market rate is, and what the property will be used for. If it's an investment property, they're going to pay a higher rate than what it would be if they're going to intend to use that as a principal place of residence. Again, there's another concession if it was a first home transfer, so they were planning to use it as a principal place of residence, and it was in fact a first home that they've owned, they may be exempt altogether depending on what that market value is. If it was under 750,000, it would need to fall under that threshold to make transfer duty not payable for a first home buyer. There's also other fees to consider, including the titles office lodgement fees. So when transferring property to anyone, we need to do up what's called a Form 1 transfer document and lodge that with the titles office to basically have the new owner listed on title. Now, titles office charge a fee. Again, that fee is based on what the consideration is, so what the purchase price is. So if it's a gift, it'll be a nominal amount, which is currently around $238. That fee will increase slightly come the new financial year. But if it's a higher amount, again, it's scaled based on that amount. It could be, 2,000, 3,000, 4,000, just depends on what that amount is. The other thing to consider as well is capital gains tax. So if we are selling a property to someone else and it wasn't maybe a principal place of residence, it was an investment property, then the capital gains tax could apply based on the property's market value and, depending on the ownership circumstance, as I said, if it is investment property rather than a principal place of residence. Other things to consider are the pensions. So if we are gifting property, it could affect the government pensions that you're actually going to be entitled to, as income from the property will be considered. So, all of a sudden, your principal place of residence could be sold, and then you've got this big lump sum of money in your bank account, which Centrelink will take into account to then work out what your pension should be. There'll also be bank fees. So the mortgage conditions might change. You could incur additional fees, but also to actually, if there was, like I said, a mortgage over the title, we need to get that released, and the banks will often charge a fee to release that mortgage from the title. It's not exorbitant. Each bank is different, but, might be, $1,000 or something like that. And then obviously we need to consider legal fees. So, engaging solicitors like our firm, that there's a cost involved in doing that. And that fee for service is also needing to be paid to ensure that the property is properly transferred and we take care of, stamping, or if we're acting for the buyer, but if we're selling, the sellers will still take care of stamping the transfer documents, but also titles lodgement fees and things will take care of all that as part of the property transfer. Example of financial consideration then. So if in this situation we've got a home that's valued at about $1 million, we're wanting to gift that home to our child, the cost payable in fees will be to the state government is $30,850 for transfer duty. This is also formally known by a lot of people as stamp duty, and also $238.14 for the titles office registration fees if the transfer is only document lodged at that time. So if there was a mortgage need to be put on as well, and if there was also potentially a release of mortgage from the parents that were selling the property to the child or gifting the property, there would be that's a standard fee. So it'd be that fee times 3. As mentioned before, though, these are the fees until the end of financial year for the titles office, and they do increase every 1 July each year. So they will go up slightly, generally just by CPI. Now, this doesn't also include any of the legal fees, though, or the electronic settlement fees. Currently, we're bound to settle transactions like this via electronic means, and we use PEXA, which is what most solicitors will use, and they charge a fee which is roughly around $145 per transaction. This is also on the assumption that the transferee, so the child, complies with the requirements for the home concession. So in this case, they wouldn't be eligible even if they were a first home buyer because it's above the $750,000 threshold, but they still could be eligible for the home concession if they are intending to live in that property for a period of 12 months within 12 months of settlement. Should they not, then that transfer duty fee will actually be higher because they won't be entitled to that concession. It'll be based on investment property transfer duty amount. As mentioned before, though, for the parents, they could also be liable for capital gains tax and bank fees as well, depending on their situation, if they've got a mortgage over the property or if it was an investment property at any point in time. Now, a common tool or structure that's currently used at the moment is the granny flat agreements. So often, sometimes, the parents have, transferred the whole of the property to the child, or gifted the property to the child, but they still want basically a life interest in that property, to essentially be able to remain a resident in a section of that property for, until the end of their life, essentially, until they end up going into care. So the way we draft that is via the granny flat agreement. So this is agreement between the parents and the children, where the parents provide the money or the assets in exchange for a guaranteed place to live for life. So they might not necessarily be gifting a property to their children in the first instance. Sometimes it's that the children have bought the property and the parents may be, funding a legitimate granny flat, like building an actual granny flat on that property. Or sometimes it's just that they're residing, in a separate part of the property, maybe downstairs and the children are upstairs, but they're again still contributing to that property in some way by means of cash or an improvement to the property. So the granny flat agreement, though, it does need to ensure that it confirms that the parties do have the right to live in the home for their life, or, like I said, until they end up going into care. It should also be stipulating and outline what actually is the financial contribution. So as I mentioned, whether it's them putting in capital expenditure to build the actual granny flat itself, or whether they're just giving the children, maybe a lump sum of money, 100,000, 200, whatever it is, for them to reside in that property, essentially like their rent for the rest of their life. But then we also need to also stipulate what happens if the agreement comes to an end. So, what happens once that parent passes away, or, they end up going into care. What happens if, there might be a child, but obviously that child could have a partner. What happens if there's a breakdown in that relationship and they need to sell the home? Maybe the home's small. These children end up having more children, or children of their own. They want to upgrade the property. We need to have contingency plans in place to allow for exits to that granny flat agreement as well. When can a granny flat agreement be used then? So when a parent is actually financially contributing that lump sum of money to building the granny flat, maybe they're renovating the child's property. So maybe it is a double-story house, but doesn't really allow for dual living, and they want to make sure they've got another bathroom or self-contained kitchen or something downstairs. They're funding that money to install those improvements to the property. Can also be used when there's a parent that has transferred ownership of their property to the child, and the child is going to be living then with the parent for the foreseeable future, or when a parent financially contributes to actually purchasing the property. So the parents are, giving the child money to purchase that property, but they're not actually going on title. They just want to have that interest in the property to be residing there. So if you are planning on being registered on title, you may want to enter into, an ownership agreement, which can be similar though to a granny flat agreement, but it wouldn't be considered an actual granny flat interest. So, it's different if the child was actually going, as joint tenants or tenants in common for the property purchase and being interested. We wouldn't be doing a granny flat agreement in that case. We'd do what's called an ownership agreement to still stipulate, who's responsible for maintenance, what happens if there's a breakdown in relationship, one party wants to sell the property, property, et cetera, et cetera. So that is different to the traditional granny flat agreement we would do. Now, what are the key features then of these granny flat agreements and the interest? So we need to make sure it stipulates that there's a right to live in the specific home for life. So whether that is, a particular section of the house, or whether that's a completely separate dwelling on that property. We need to be stipulating that the property must, belong to someone else. So, it's not the person that's got the right to live in the property. It's obviously, the child or relative that owns that property. The property must be a private residence. It can't be, that the child's renting it from someone else, because that doesn't really allow for that life interest in the property. It must also be the principal place of residence. We need to be residing there. It can't just be, like I said, investment or living somewhere else. It doesn't have to be a granny flat, as mentioned. It can just be, the same part of the building, but just in a separate section, whether that's, a particular bedroom, a particular living quarters, whatever it is, depending on the setup. The property can't be owned, by the person that's residing as their granny flat, generally the parent, or your partner, or a trust or company that you have a controlling interest in, though. So it needs to be someone separate to that. As mentioned, generally it's the children. Now, issues then when it comes to estate planning with the granny flat. So if we have sold your property and you've been paid a lump sum to build the granny flat at your daughter's house, for example, but you haven't updated your will, so it still leaves everything equally to the son and the daughter. However, your daughter's received the added value of the granny flat improvement to the overall property value. Now, if you gift a lump sum to one child to assist them in purchasing a home, but not the other child, you should be updating your will to reflect this. Now, this is often referred to as a bloomer clause in your will, and it will specify that the child's share is reduced by the amount previously gifted. So, for example, if we're planning to, maybe contribute, $300,000 to our daughter's house purchase, we need to make sure that that's allowed for in the will, so that we don't then, once it passes away, have, the other child or children coming and contesting that will, saying, hey, they've already benefited from, X amount through this improvement, and therefore we need to, be given a bigger share of the inheritance. So retirement villages. So obviously very separate to a granny flat, where we're going into, an actual retirement village situation. Now there's 3 different types of agreements that are commonly used in Queensland for these, and these are long-term leases, a loan and a license situation, or in some rare circumstances, there are some freehold retirement village agreements that still do exist in minority. So retirement villages, so the most common type of agreement in Queensland used, though, is the leasehold structure. So depending on the agreement, you may be entitled to capital gains and be responsible for any capital losses as well. So you can pay the management fee in a lump sum upfront, and if you leave within 5 years, you will generally receive some part of it back at the time of exit, and this will be based on a percentage and will be deducted from your ingoing contribution. In freehold situations, it's very uncommon, as I mentioned, in Queensland, but it's similar to owning a unit in a body corporate scheme. So you'll be paying rates and water accounts in addition to the service and maintenance charges imposed by that actual village operator. The other type of structure I mentioned is the loan and license agreement. So this is your ingoing contribution is loaned to the operator and essentially repaid without the interest when you exit from that facility. Now, what assets are not automatically covered and what you need to do about them. So assets held in a family trust. So if you are a beneficiary of a family, or otherwise known as a discretionary trust, and your interest is generally not covered by your will. So when we're doing our estate planning documents up, we need to be aware of this, because You do not own a defined share of the trust assets. Appropriate succession planning for that trust is essential. So when we are drafting estate planning documents, we'll ask the question, are you the beneficiary of any family or discretionary trust? If the answer to that is yes, we'll be asking for a copy of those trust deeds. We'll be checking, things, obviously make sure you're a beneficiary, but mainly who is the appointer of that trust. Whoever's the appointer, there'll generally be mechanisms to allow for an alternative appointed to be appointed, and within your will, that is where we will make reference to your family trust, but also appoint an alternative appointer, and that appointer's role is to basically distribute assets to the beneficiaries. The other thing that's not covered off in your estate planning documents or your will is your superannuation. So superannuation does not automatically form part of your estate. So to ensure that your super is actually distributed according to your wishes, you need to consider putting in place a valid binding death benefit nomination. Now, those binding death benefit nominations are generally lapsing. So they generally only last anywhere from 2 to 5 years, depending on who your industry super fund is. So if you haven't done one of these in recent years, you don't remember doing one, I strongly recommend making contact with your superannuation company to make sure that you've got one in place. And if you don't, make sure you have one drafted so that it is put in place, and make sure you're also then diarising the date that it expires so that you can constantly keep updating that as needed, and it will remain in place. I always say if clients haven't updated their binding death nomination for whatever reason, you were to pass away without having that updated, likely the superannuation trustee would look at, who are your beneficiaries under your will. But in general terms, your will doesn't cover off on your super. So it is important to do that. The other thing that your will not include is life insurance. So if you do have life insurance policies in place, the proceeds are often paid directly to the nominated beneficiary rather than who's listed as the beneficiary in your will. So you need to ensure that you're reviewing the beneficiary nominations regularly to ensure they remain current and as to who you want to be nominated as the beneficiary for your life insurance policy. Now, what assets are not covered still? Continuing on, assets owned by a company. So if you are the shareholder of any companies, they will not be covered off on your will. So we do again ask the question, are you a shareholder in any companies? And if the answer to that is yes, we'll ask for a copy of the Constitution and Shareholders Agreement to see how we go about nominating an alternative shareholder for that company, and make sure again that we include provisions for that in your will to ensure that those shares are given to who we want once you pass away. The other one that is not covered off by your will is jointly owned assets. So assets that are held as joint tenants typically will pass automatically to the surviving owner through the right of survivorship and do not actually form part of your estate under your will. So, for example, quite often properties are owned, as husband and wife, as joint tenants. It doesn't matter what your will says, that property won't go to the beneficiaries in your will. It will go to that surviving joint tenant, which is often the spouse that's listed. The other thing is testamentary trust is a common one that we will draft, which will basically be included within a will. So a testamentary trust is an actual trust that's established through your will and will only come into effect upon your passing. So rather than the assets being distributed directly to the beneficiaries, they are held and managed by a trustee for the benefit of those beneficiaries. Now, the key benefits of a testamentary trust is asset protection. So it helps protect inheritance from financial mismanagement, bankruptcy, any creditor claims, or any relationship breakdowns. So, for example, often, parents may want to have a testamentary trust attached to theirs because, their son, daughter has gone into a relationship with a partner. They're not quite fond of it. They don't think that relationship's going to last. They're worried that the in-law is going to, have a right through a matrimonial claim to potentially the inheritance that their son or daughter is going to receive from them. So that's, the relationship breakdown and why they would do it for that situation. Another key benefit is for controlled distribution of wealth. So it allows the assets to be managed and distributed according to what your wishes are over time. It can also provide support for vulnerable beneficiaries, so can provide ongoing financial support and protection for beneficiaries who are minors, have disabilities, or require assistance managing finance. So we've often had clients where, you know, they've got a disabled son or daughter that they want to ensure is you know, drip fed and essentially given, you know, small amounts of money to clothe, feed, educate, support that child, you know, over a long period of time. Whereas with a will, you know, it will have a vesting age for children if they're minors, but essentially once they get to that age, that the whole estate is essentially distributed. Where for a disabled child, that might not be reasonable and feasible for them to do that, which is why they'll do it. Testamentary trust can also provide flexibility. So it allows the trustee to adapt distributions to meet the beneficiary's changing needs and circumstances. So an example there, we've had a client where they wanted to give, you know, sums of money to a parent, you know, was living overseas in China, and they've just given, you know, kind of like, you know, their own pension, like giving them a set sum of money, you know, every month, and that's been done through that testamentary trust. Now I've got listed here potential tax advantages. So it may provide tax effective income distribution opportunities, particularly for families with children. Obviously that one's a big thing in contention at the moment with the recent budget that was announced. None of that law has been actually passed as yet, but if it does, you know, the tax advantage certainly won't be there. So testamentary trust, though, it's also known as a bloodline trust. You can now have a perpetuity period of up to 125 years. It was previously 80 years as well. Okay, and that's basically it. So hopefully given you a bit of background now to, you know, what is a testamentary trust, you know, the importance of having your estate plan in place in terms of your will, what's not covered by your will, the retirement options in terms of the legal agreements that go with them in Queensland, and also, yeah, just basically estate planning in general. So I'll hand over now to Seb and Tony to talk more about, you know, the asset protection when it comes to aged care planning in Australia. So thank you both.
Yeah, thanks so much, Kaylee. Just before we get into it, I just wanted to kind of preface, you know, my role in this, especially through working with Tony, who's got so much experience in financial services, and he's been working in this space for going on 8 years now. We have the current system in Australia is very reactive, meaning somebody has a fall, goes to aged care. There's not a lot of conversation around planning or education for that matter. It's a very confusing space. So our mission and my role in this business is to get our message out there, to get people comfortable with having the conversation. So we're going to point out a few things over the next coming slides. So thank you. Here we go. Do you want to go through this one, Tom?
Sure. Am I pushing the slides?
If you want.
Oh, look at that. What families are really up against? Okay, so look, Kaylee probably summed it up in what I've found in this space is that non-preparation is your biggest trap. So all those things Kaylee was talking about there, we find families are very reactive in this space. So there are 5 different main fees. And when I say reactive is that they're not planning well in advance. If they plan well in advance, like Kaylee was talking about with wills and updating and all the things they can do, a lot of these fees that you see here won't appear. So basically what you're really up against if there's an event and there's been no planning, families up for, that's got 4 fees there, but it's actually 5. We'll go through those. Basic daily fee, which is everybody pays regardless of means. And it's a basic fee which covers things like cleaning and feeding, very basic. The second thing that's got to be navigated is the room cost. And this is where early planning and preparation is really, really important, because families are often trying to negotiate what's going on here when they're under extreme pressure to make a decision, because it's about, as Sebi often calls it, the triple stress, where somebody's got to go to care and all of a sudden, we've got to find a room. And as we've heard in the media, that they're sometimes very difficult to get. So when they're difficult to get and families are vulnerable, they've got to make quick decisions, and quick decisions sometimes lead to these massive fees being confronted with these massive fees, whereas planning could have fixed it. So the room cost, that's called a DAP, which is short for a daily accommodation payment. All that means is that instead of paying a lump sum for a room, which could be up to $750,000, higher in some other places, someone decided to rent the room, or at today's rate, it's about 7.96%. So if you're renting a room which is $750,000, you're going to be up for around about $59,000 a year in fees for the room. So far, for a basic daily fee of $24,382, the first one there, and then if we're renting the room, it's $59,700. And now we move into these other two fees called a hotelling contribution and a non-clinical care contribution. Both of these are means tested, and that means that they're measured against your income and your assets at the time. They can be up to $8,000 a year for the hotelling contribution, which is another extension of the first one, cleaning and catering. It was a new rule that came in November last year. And then the fourth one there is called a non-clinical care contribution, which covers personal care activities. And if you've got assets over $536,000, which a lot of people have today just in their home, it can be up to $39,000 a year. The fifth fee that's not shown there, I call the dignity fee, and that's where the person going into care, actually, if it's a male or a female, might like to have a wine with their meal, or they might like to if they're a lady, might like to get their nails and their hair done at the end of the month, or they might like to have coffee during the day, or a pizza on Friday night. Those things are actually an additional cost as well. So what families are really up against in year one, if they do no planning, this is what we're sometimes picking up the pieces for families who are in a panic because they've been confronted with these fees. It's not the aged care people's fault, because all they're doing is using the rules to establish what you've got to pay, or Centrelink assesses it. So planning in advance can reduce a lot of these fees. There are probably a couple of pension, so risks that can catch families off guard, pension at risk. So I'd like to tell stories here. The example would be sometimes people get told to sell their home and they're on a pension. And as Kaylee alluded to earlier, once the money hits the bank account, it can be assessed by Centrelink. There are certain rules that can slow these things down, but it can actually eliminate a pension totally. Well, what a lot of people don't know is that if the wife's got to go into care and hubby stays at home and they're on the pension, they both now get assessed as a single pensioner, which can help with paying some of the fees. Home sale pressure, often because no planning's been done, a room is offered, yes, it costs this amount of money, well, we don't have that, so people feel like they've got to sell the home. However, it might disturb their will wishes, because when we meet people, one of the things we ask them is, well, what are your will wishes? And 9 times out of 10, they say, well, we want the house to go to the other person first. And as Kaylee pointed out, it's a joint asset. It doesn't fall in the will. And the third thing is, no one leave to the kids because they can't get into the market. Now, for families under pressure because they've been told a room's $750,000 and they want to pay that instead of paying the $59,000 a year, that house can disappear quite quickly, as can the pension, and also disturbs their will wishes. So this unexpected cost exposure all comes from reactiveness, and that is after an event. So pre-planning really can allow families to sit around the table, navigate this space, have a look at it, work out what might be best, and then adjust their will and estate planning, their will wishes, or their plans accordingly. What giving money to children really costs? Well, we meet a lot of people who, when we show them what the fees are, if they go to care, they say, oh, what about if we do this? What about if we give a couple of $100,000 to the kids? Well, Centrelink will look at that, and they call it deprivation, especially if you're a pensioner. So you're allowed as a pensioner to give away a rolling $10,000 a year over a rolling 5-year period. But if you're gifting more than that, Centrelink will count it as deprivation. So you're allowed to give away for your $10,000, but if you gave away $100,000, there'd be $90,000 in that first year that you've what they would call as deprivation. And the reason they say that is, well, you've done that to reduce your fees, which is not inaccurate. Aged care fees increase. The same thing. Okay, so excess reducing your pension entitlement 5 years. Aged care fees increase if you're giving your money away. They can. Most common surprise. Most families have already gifted money and don't realise the potential consequences. I think we've covered that. And Centrelink will unwind it. So, for example, Kaylee covered about the granny flat. So the granny flats have their place, but they have to delicately dance around the rules with aged care, because if you decided on the Friday before the Monday going into aged care, we're going to use the granny flat rules like Kaylee explained, and it ended up being the reason you did it was to reduce fees. Centrelink will unwind it and just assess you as you were on the Friday. So again, it's about sitting down and understanding what the different rules and implications are, and understanding, once you understand them, and we try to empower people with this information, not tell them what to do, so that they put them in the driver's seat to understand, hey, if we do that, that's what's going to happen. And then once people can navigate that space, they're a bit more empowered. What Centrelink actually sees: transfer of your home, transfer of the title of your principal rights to adult children or a trust while retaining. Yes, I think Kaylee covered that well. So here's an example of what some people have done who we've met, is that longer than 5 years out from entering care, they made a decision that based on their original instructions with their will, they want to keep the home in the family and they want to take advantage of the growth in the market. They might transfer the house to one of their adult children in exchange for a right to live there for the rest of their life. Now, yes, they've got to pay the stamp duty, but what it does do is retains the property in the family assets for basically for as long as mum and dad are around. Purchase another property. Yes, Centrelink, you can actually purchase another property provided you use all your funds. So what that means in English is if you sold your home for $1 million and you were greater than 5 years out from retirement, from possibly going to aged care, and you understood the thresholds with aged care, you could add another couple of $100,000 to it and purchase a property in another person's name. Another person could be a child or a trust, and there's no limit. So we find sometimes people are doing that in exchange for a right to live there. And in our agreements that we have with working with solicitors, exactly what Kaylee covered was that, if there's a marital breakdown, what happens there? How's that asset protected, et cetera, et cetera. So all those things are put in place. But again, our extension of this is helping people understand how Centrelink works, how the aged care works, and how in conjunction with their will and estate planning wishes, so that they can possibly navigate the best result for them well in advance, not when an event has happened. What significantly impacts family wealth? I'm repeating myself, but leaving plenty too late, because most decisions are made in the hospital corridor, and families who plan ahead have far more options. And the reality is that humans are emotional beings, and of course, if you've got a situation where a mum and dad or a grandfather or a grandmother has had a serious stroke and they've got to go to care, of course we're concerned. And it doesn't become about money then, it becomes about making sure they're okay. So leaving planning too late goes back to the first slide. We're paying up between $90,000 and $100,000 a year because the Centrelink are just assessing what you have. Assuming the home must be sold, we hear that so often. Had a case recently where a single man, he was a sole beneficiary of his mum's property at Beachmere. He went to aged care facility to find a place for mum because she had to go to care. They told him to sell her home because he was the enduring power of attorney to pay for the room. We had a brutal conversation, and it was, how long do you think she's got? He said, she won't last 6 months, and she had money in the bank. So we came up with a strategy to use somebody the money in the bank to pay the aged care people. They still drew some of the fees out of the lump sum that was paid. She only lasted 5 months, but the home was retained as per her will wishes, and that home continues to grow today. Gifting without understanding the consequences, I think we've sort of covered that a little bit. Centrelink will look at it as deprivation, but there are things you can do. Centrelink has a rule called the reasonableness test, which can actually allow people to pay up to, depending on their age, up to $700,000 or $800,000 for a right to live in somebody's home, in their kid's home, without being called deprivation. A little known rule that a lot of people aren't aware of. Making decisions during a crisis, yes, as humans, stress and time pressure, it's been proven we make poor decisions when we're under major financial and legal pressure. Not seeking specialist guidance. Yeah, this is really important because in Australia, I'm sorry to say, but the specialist guidance is very limited in this area. It's a reactionary model. It's one after the event. There's very, very few people operating in the space. We're sitting down and asking families to plan 5 to 10 years out, which is our objective, and we find that can help families be prepared for this this thing that does happen to families.
I just want to give a great example with point number 3 there before we move on to the next slide. We had a case recently where the young lads, they're probably in their 40s, they engaged us. Mum had sold the home on the way to care. And basically they said, great, we're going to hand over the 400 to the facility. That's around the area of the price range they were looking at. And the remaining funds was agreed by the family that the boys are going to split it in half and get a couple $100,000 each, essentially, for school fees, their own mortgages, their own problems. But once they got to the bottom of it with us, they were made aware that that money still counted for the aged fees, even if she was to gift it to them anyway. So they were shocked, genuinely, because they now were basically under the impression they weren't going to get that money, and all of it starts to unravel. But please continue, Tony.
Okay, do we have another next slide? What planning actually achieves for families? Oh, well, there's a couple of examples. We'll start with the first one where we there was a planning we did for a lady, and then inside the 5 years, because Centrelink looks at the 5 years, we did some serious planning. Centrelink challenged the planning, and all we did is produce the documents that people like Kaylee prepare, and that was the family agreement, the granny flat agreement, and the lawyer had interviewed mum to prove that she had been influenced. She was interviewed separately. That was all done and all that documented. So when Centrelink asked us to produce the information, they ended up saying, yep, she does not have to pay the big fees. And we got a testimonial from the client to say we'd saved them $600,000, which was fantastic. We had a situation where nobody had done some planning, and their church recommended that they go to their facility because they'll help them. So vulnerable family, go to the church recommended facility, sat down with the church people, and they gave him a room. It was $350,000 at the time. And then they handed over, the lady handed over the full life savings of $200,000. And 6 months later, she's worrying and stressing about money. So when we looked at it, they breached the act because the $200,000 they had in the bank, $100,000 was hers, could not be assessed. That means they had to assess him on his $100,000. At that time, the law said the maximum that they could take was $46,000 because he had to be left with some money in the bank account. We actually approached the facility, and the whole $200,000 was refunded to that lady. Plus, they found there were some other fees. And we're not the only ones finding it. We're a very tiny operator in the market. OPAN recently produced some information that across Australia, 72% fee errors. And that was I don't know how many, Seb, how many people was that?
OPAN had done, so OPAN's the Older Persons Advocacy Network, and they generate a report each year. They had 72% of their cases were all to do with overcharging and fee errors and confusion. And that was about 800 cases. They had 780 cases just in that financial year.
So what that proves, it just proves one thing. It proves that people aren't getting help, because the frontline staff in the aged care facilities, I'm sorry, they're not 100% trained in this area. We have professional advisors out there who are not educating their clients. So it is what happens, these errors come, families are under pressure, the frontline people have to do their thing, and this is where these errors come from, lack of education. So it comes back to people need to get in front of this and understand, because it's overwhelming and these errors happen. And we've only found a couple ourselves, so I don't know how many else are out there.
Yeah.
Plan ahead. Yes, review your estate planning documents. Now, we've just recently done some more research here, and people like Kaylee are fantastic because they put your assets and your will wishes down. But Kaylee's not in the room 5 or 6 years later when an aged care event can happen. She's done what she could do because people want to establish how they want to have their assets protected. But people also have to be aware that if you sit down and do your aged care planning, or you've got surrounding seniors, they may need to review their estate planning doc in conjunction with a possible aged care event. Know the gifting limits before acting. Yes, definitely. Granny flat agreement can be a tool that's useful. Can't be done on the Friday before the Monday because Centrelink will undo it. Understanding the SBI rules. SBI is short for separated by illness, where a family who's separated can get the single pension. Get the right information early. The families who navigate aged care most effectively almost always had at least a basic understanding of the system before it became urgent. Very, very important. And understand all the accommodation options, because once you understand the difference between the lump sum and the daily rental and a combination and how each one impacts a pension and estate and cash flow, that's when you start to get to the bottom of, okay, so this is how this works. And reality is, it's up to us as individuals to take control and take responsibility of not only our estate planning and future, but also this aged care stuff is real. How are we going? Who's this for? If any of this described you, this conversation matters. So again, I'm repeating myself, but you can't say it enough. Planning ahead for yourself, thinking about what aged care might look like, what it costs and what options exist while you still have time to act. Supporting aging parents, an adult child managing aged care decisions for a parent, navigating one of the most complex financial systems in Australia. I can tell you now, somebody's had nearly 50 years in financial services. This is the most complicated financial scenarios I've ever come across. It's more complex than superannuation. Protecting family assets, thinking about how to pass on wealth to the next generation without losing it to unplanned aged care and fee errors. So yeah, I'm of the vintage where I paid 18% for a mortgage, where my families were told when they were raising kids 30, 40 years ago that when they get to the end, they'll get a pension. They do. But what they weren't told about is someone implemented a system that started that they've been changing the rules since 2014, and 16 years later, 2014, we've got all these problems that the seniors who are the infrastructure of this country have got in our face because somebody's brought in a system which is trying to track their wealth. So all we're trying to do is help people understand that with the aged care costs rising and increasing scrutiny of assets and means testing, you need to understand these issues, as they can make a substantial difference to your financial future and legacy if that's what you want to do.
Awesome. Thank you very much for that, Tony and Seb. Obviously, so much to think about for people that have relatives or family members entering into aged care. It is a bit of a minefield. So I totally understand that your services are very, very valuable for those people to plan ahead to avoid, some of these costs, and that can come at a big shock to family members. So we'll open it up now. If anyone's got any questions they would like to ask, just take yourself off mute. Otherwise, feel free to put a question in the chat bar. So we'll just give it a minute now to see if anything comes through. Got our contact details up here, so feel free to reach out to us directly. You should have received Seb and Tony's details as well. What we'll do as well at the conclusion of this is we'll send a copy to everyone that's registered of this recording for the webinar, but we'll also send a copy of the slides as well. We'll reach out to everyone as well to see if they do want to have a consultation. Feel free to ask us more questions. Otherwise, get in touch with us directly, and you can ask your personal questions that may be pertinent to your own situation. One comment there just says thank you. I think that's all just a thank you. I don't think there's a question. Thank you. Excellent content. Really appreciate your insights. So thank you very much for that, Sloane. Appreciate that. So yeah, hopefully that's helpful for everyone. Answered a few questions or made their mind boggle a bit more. But yeah, hopefully we can chat with you all soon for some further information. But thank you for joining us, and thank you very much to Tony and Seb for joining us for this one. We really appreciate your time.
Thanks.
Thanks for having us.
Thank you. Yeah.
Thank you. Have a good day, everyone. See you later.
Cheers.
Bye.